Hello and welcome. I hope all of you are well. Today in this lecture of company law, we will be continuing with our chapter of meetings, in which our current topic today will be resolutions. Resolutions which are passed in the general meetings. This is covered under section 114 to section 117. I hope all of you have been revising the topics that we have so far done. I have nearly completed the whole of the meetings chapter, which is also known as Management and Administration for CA Inter examination. We have only two topics left in this particular chapter now, which is resolutions and the other one is minutes. Once we are done with this, it will be up to you to revise this lecture and do write to me in the comment section if you require any more help from my end on this chapter. I would be coming up with some more lectures with case studies which have come in the examination previously from this chapter. As I had told you, this chapter has quite a good amount of weightage for your CA Inter examination. So do take this chapter seriously. I have taken you through the minutest detail, each and every provision, and the ICAI module has been completely covered in my lectures. So you can refer to these lectures multiple number of times to ensure that the revision is done. Okay, so without wasting any time, let's start off with resolutions. Now, resolutions are basically the formal decisions. Resolutions are formal decisions of an organization. Resolutions are formal decisions of an organization. What do you mean by formal decisions? Formal decisions means the business decision which have been taken by the company. See, the company is an artificial person. Company is an artificial person. It cannot itself take decisions. Hence, for taking decisions, meetings are required to be held. And in such meetings, the owners of the company who are the shareholders would approve any business decision which has been proposed by the board of directors. I hope this relationship between shareholder and board of director is clear to you. Now, such decisions which have been approved in the meeting is known as formal decisions, is known as resolutions. Okay, so we will be covering section 114 in this particular edition, which covers ordinary resolution and special resolution. Okay, so there is one more concept which has to be understood by us. Let me depict you with this particular chart. It's a very simple topic and it won't take much amount of time also to understand this topic. First of all, any business matter which is placed in the general meeting for approval of the shareholders, which is placed or which comes before the meeting, is known as motion. It is known as motion. So any business matter which is placed in the general meeting before the shareholders for their approval, disapproval, certain action, or any order of something to be done. Such business matters are known as motion. This is clear. Once the motion is placed in the meeting, it is also known as proposal. Also known as proposal because it is a proposed business item which has been laid in the general meeting by the board of directors. Now, in the meeting, there will be discussion which will be held and voting which will be held. We have already covered voting process and we have understood how it works. Once the voting is passed and if the requisite majority has been received for the particular motion, then the motion will be said to be adopted. And once it is adopted, then the motion would become resolution. the motion would become an resolution. So you are able to understand the difference between motion and resolution. Motion means anything placed in the meeting for approval or disapproval from the shareholders. Once it is voted upon by show of hands or by electronic means or by poll or by postal ballot, and if the votes are received in requisite majority in favor of the motion, then it is said to be adopted and called as resolution. I hope this is clear. So every motion that is placed in the meeting need not be adopted or become a resolution. Okay. So this part of motion and resolution is clear to all of you. I hope it is. Let's move on to the next part, which is resolution types. Types of resolutions. As I said, there are two major types of resolutions. One is ordinary resolution and the other is special resolution. Now we have done one topic in section 102, which was about ordinary business and special business. Do mind over here that ordinary business and special business do not have any relation with ordinary resolution and special resolution. Both are different concepts altogether. Many students do think that ordinary business hai, so it might be ordinary resolution, and special business hai, so it might be special resolution. This myth is completely wrong. How do you understand whether a particular resolution is ordinary resolution? If in the language of law, in any provision, it is written that a resolution may be passed in the general meeting. It is only written that the resolution may be passed in general meeting. In general parlance, in general interpretation, if only resolution is written, then it will be ordinary resolution. But if the provision specifies clearly for such an act, a special resolution needs to be passed. So it is specific in nature. Interpretation also will be specific in nature. Hence, it will be special resolution. So if the act or the provision of the act specifies clearly that a special resolution is required, then and then only a special resolution will be required. It is not based whether it is on ordinary business or special business. I hope this concept is clear to you, because many people do carry this concept, which is completely wrong. Okay. Now, as I said, there are two types of resolution. One is ordinary resolution, the other is special resolution. Ordinary resolution is covered under section 114, 114, subsection 1, and special resolution is covered under section 114, subsection 2. Now, ordinary resolution is a simple resolution with simple majority. That means in a company, if there are 100 members and 51 members, that is more than 50%, 51 members vote in favor, then we would say that ordinary resolution has been passed. Okay. Now, what is special resolution then? Special resolution is a resolution where the votes in favor have to be at least 3 times. At least 3 times of the votes against. So, in ordinary resolution, I would say that the votes passed in favor exceeds the votes passed against. But in special resolution, I would say the votes passed in favor is 3 times the votes passed against. Then I would say that special resolution has been passed. So we would require, when I say 3 times, that means we would require at least or greater than 75%. 75% of members present and voting in the meeting along with their proxies. This is clear. We may also call it as 3/4 majority. 3/4 majority. Okay. So this concept is clear. This must be already known to you because resolutions is something that we have been learning from our 12th standard. In the subject of secretarial practice, if any one of you had opted for secretarial practice. Okay. Now, in terms of ordinary resolution, let us try and understand what are the conditions for the same. It is covered under section 114, that is 114, subsection 1. Ordinary resolution, if notice is required, then it should have been duly given as per the Act. So in general meeting, obviously a notice is required. A notice shall also specify the resolutions that are going to be passed, and it shall be specified that it is going to be an ordinary resolution. So notice shall be given duly as per the provisions of the Act. Which is this provision? This provision is section 101. This is clear. The second condition is you require a majority of greater than 50%. That means votes cast in favor exceeds the votes cast against the resolution by the members so entitled and voting in the meeting. Even the proxies votes will be counted for the same. Okay, this is clear. Ordinary resolution is simple. Next, section 114, that is section 114, subsection 2, special resolution. Now, in case of special resolution, the intention to propose the resolution, has been duly specified in the notice. So that the intention that the company wants to propose an special resolution shall be clearly specified in the notice calling the general meeting. That is point number 1. It should be clearly specified in the notice. This notice shall be given as per the provisions of the Act, which is 21 clear days before. Again, it will be under section 101. Okay. The notice shall specify the resolution to be passed as special resolution. It should be clearly specified. It is a special resolution which is being proposed. And such omission would invalidate the resolution. The company has, ABC company has given a notice to the shareholders, but has not specified a particular business item which was to be passed by special resolution. In that case, even if the special resolution is passed in the meeting, it will be invalid. Second scenario, in case the company specifies in the notice that a resolution has to be passed, but it does not specify whether it is a special resolution, then even if the resolution is passed in the meeting, still it will be invalid. So this omission will render it invalid. I hope this point is clear. This is an important point. Next, as I had covered under section 102, we would have to attach or annex an explanatory statement justifying the reason for such a resolution to be passed. So I hope this is also clear. We have already discussed about explanatory statement. You can search my videos in YouTube itself as section 102 explanatory statement. If you have understood that particular video, do let me know in the comment section. Also, the notice lecture is also available, section 101. So this is basically the process for special resolution. And in special resolution, you would require 3/4 majority. That is, the votes cast in favor is 3 times the votes cast against. If these conditions are met and the provision of section 114 is met, then you would say that the resolution is passed, and that resolution which has been passed will be the decision of the meeting, the decision of the company, and has to be legally adhered to by the company. I hope this is clear. And once such resolution is passed, it will be binding across the company. Whether an shareholder has voted against the resolution, still it will be binding upon him. So this is the first part of the topic of resolution. We have another two topics, that is section 115, resolution by special notice, section 116 and section 117, which we will be covering in my forthcoming videos. So stay tuned to the videos as we are coming to the end of the meetings chapter. And one very important topic of minutes will also be uploaded on this channel. So that's it for this particular lecture. If you have understood the lecture, then please press the like button, and if you have not yet subscribed to the channel, do subscribe to the channel and share this video to the maximum number of students who might be having a requirement of the same. Thanks a lot.